In the Declaration of Independence in 1776, Thomas Jefferson wrote the words that define the American creed. We hold these truths to be self-evident, that all men are created equal. And yet, Jefferson himself was an enslaver. He held more than 600 people in bondage over the course of his life. He publicly denounced slavery, calling it a moral depravity, a hideous blot, and a practice that violated the laws of nature. And yet, even as he called for the total emancipation of enslaved people, Jefferson, like many of his fellow Virginia slaveholders, such as George Mason and James Madison, would not free the people that he himself held in bondage. How did Jefferson reconcile the founding creed of America with the story of slavery in America? The truth is that he didn't. Jefferson always recognized slavery as a violation of the principles of natural law that were expounded in the Declaration of Independence. Indeed, he said, "I tremble for my country when I reflect that God is just, that his justice cannot sleep forever." That's from the notes of the State on Virginia, where he endorsed total emancipation. He said, "The spirit of the master is abating, that of the slave rising from the dust, his condition mollifying, the way I hope preparing under the auspices of heaven for a total emancipation." In fact, Jefferson's favorite law professor, George Wythe, practiced as well as preaching the principles of natural justice. He not only emancipated all of the people he held in bondage during his lifetime, but also made arrangements for their support and livelihood. George Washington provided in his will that all the people that he enslaved should be freed on the death of his wife, and at the same time, other enslaving founders from Virginia, such as Madison, Mason, and Jefferson, maintained this hypocritical position where they professed a desire for the abolition of slavery in theory, but refused, even after death, to free their own enslaved population in practice. So what can only be called the hypocrisy of Jefferson, Madison, and Mason, in contrast to the more principled conduct of Washington, George Wythe, and Benjamin Franklin, who, by the end of his life, came to support total emancipation. The self-evident explanation is greed. To put it simply, Jefferson was insincere about slavery because of his avarice. He enjoyed the lifestyle that enslaved labor made possible, and he was unwilling to give it up. And in moments of self-awareness, some of the enslaving founders were candid about their hypocrisy on the question of slavery. Consider Patrick Henry, who so memorably declared, "Give me liberty or give me death." "Is it not amazing," Henry asked, "that at a time when the rights of humanity are defined and understood with precision, in a country above all others fond of liberty, we find men adopting a principle of slavery as repugnant to humanity as it is inconsistent with the Bible and destructive to liberty?" That's Henry writing in 1773. And he added, "Would anyone believe that I am master of slaves of my own purchase? I am drawn along by the general inconvenience of living without them. I will not, I cannot justify it." Today we'll talk about how those who fought to end slavery rooted their own crusade for emancipation in the inspiring words of the Declaration itself, calling on their fellow Americans to live up to the best ideals of the Declaration's promise of freedom and equality. And we'll talk about how the promise of the Declaration was resurrected by Lincoln at Gettysburg, enshrined in the Constitution after the Civil War, thwarted again after Reconstruction, and resurrected once more by Dr. King on the Mall. All right, let's go back to January 1777. That's when Prince Hall, a free African-American in Boston, offered a petition for freedom to the Massachusetts House on behalf of 7 African-Americans. And the petition quoted the Declaration of Independence, calling on the Massachusetts legislature to abolish slavery as a violation of principles of natural equality. This is Prince Hall. "Your petitioners apprehend that they have, in common with all other men, a natural and inalienable right to that freedom which the great parent of the universe hath bestowed equally on all mankind, which they have never forfeited by any compact or agreement whatever," Prince Hall wrote. Massachusetts' highest court would go on to declare slavery unconstitutional in 1783. One of the most powerful voices for this inspiring vision was Frederick Douglass himself, with his famous speech, "What to a slave is the 4th of July?" Douglass was born an enslaved human being in Maryland, later escaping into freedom and emerging as one of the leading abolitionist voices in the 19th century. And he gave this speech on Independence Day for the Rochester Anti-Slavery Sewing Society in 1852. It became one of Douglass's most famous speeches. It criticized the chasm between America's founding principles and the institution of slavery. Let's walk through this inspiring speech together. Douglass began by asking his audience to put themselves in his shoes as a formerly enslaved person. "What to the American slave is your 4th of July?" he asked. I answer, a day that reveals to him, more than all other days in the year, the gross injustice and cruelty to which he is the constant victim. The Declaration of Independence had asserted that all men are created equal, but that promise was inconsistent, Douglass said, with the reality of chattel slavery. "I will not enlarge further on your national inconsistencies," Douglass said. "The existence of slavery in this country brands your republicanism a sham, your humanity a base pretense, and your Christianity a lie." Nevertheless, Douglass denied that the Constitution itself was pro-slavery. When James Madison's notes were published in 1840, Douglass read Madison's declaration that the framers had refused to enshrine into the Constitution what Madison called a right to property in men. And Douglass said when he read those words, that transformed his own conception of himself as a man and as a citizen. And Douglass challenged many of his own abolitionist friends to reject a pro-slavery reading of the Constitution. Here's Douglass. "Fellow citizens, there's no matter in respect to which the people of the North have allowed themselves to be so ruinously imposed upon as that of the pro-slavery character of the Constitution." He challenged them to read the Constitution in a way that advanced the cause of freedom. This is Douglass. "In that instrument, the Constitution, I hold, there is neither warrant, license, nor sanction of the hateful thing. But, interpreted as it ought to be interpreted, the Constitution is a glorious liberty document." In Douglass's view, slavery was inconsistent with the preamble to the Constitution and its core purposes. Here's Douglass again. "Now, take the Constitution according to its plain reading, and I defy the presentation of a single pro-slavery clause in it. On the other hand, it will be found to contain principles and purposes entirely hostile to the existence of slavery." And finally, Douglass called on the nation to vindicate the principles of the Declaration of Independence and to abolish slavery. "The arm of the Lord is not shortened, and the doom of slavery is certain," he declared, while drawing encouragement from the Declaration of Independence, the great principles it contains, and the genius of American institutions. "My spirit is also cheered by the obvious tendencies of the age." Well, let's now review the history of slavery from the founding through the abolition of slavery after the Civil War, which culminated in the ratification of the 13th, 14th, and 15th Amendments to the U.S. Constitution, making Douglass's dream a reality and culminating in what some have called the second founding. Slavery is older, of course, than the U.S. Constitution, and was written into colonial law as early as the 1660s in places like Virginia and the Carolinas. By the 1700s, these colonial slave codes transformed slavery itself, making it inheritable. In other words, it was passed down from parent to child and was a lifelong condition based on race. This was known as chattel slavery, and it represented a fundamental shift in how the institution of slavery worked. In the 1700s, chattel slavery expanded, and it became a massive part of the Southern population and white Southern wealth. With the signing of the Declaration of Independence, slavery clearly clashed with the founding ideals of America, and it became a central issue at the Constitutional Convention. What role did slavery play there? All told, 25 of the 55 delegates to the Constitutional Convention were enslavers, and slavery was critical to many of their wealth and to the economies of their home states. At the Constitutional Convention, as Frederick Douglass later emphasized, the framers refused to recognize an explicit right of property in men. However, they did compromise over the issue of slavery, and their debates were central. The main clash was between the delegates who were willing to end the international slave trade, which included most of them, and the delegates from South Carolina and Georgia. And in fact, it was South Carolina and Georgia, according to George Mason, that insisted on putting a time limit on the point at which Congress could ban the slave trade, and said that it couldn't be banned until 1808. And that was the first central compromise that was made. And Mason was appalled by it, and after the convention, he wrote to Thomas Jefferson and objected that the delegates from South Carolina and Georgia had prevented the immediate ending of the international slave trade, which Jefferson and Mason and most of the other delegates viewed as a clear violation of national rights. And then there was the 3/5 clause. The U.S. House of Representatives draws up districts based on a state population. The more populous the state, the greater number of districts it gets. The big question in the debate was how to count enslaved people when setting the number of representatives in the U.S. House. At the convention, pro-slavery Southerners argued that enslaved people should count as a full person, but anti-slavery delegates shouted hypocrisy. Pennsylvania delegate Gouverneur Morris called slavery a nefarious institution, the curse of heaven on the states where it prevailed. So how could Southern delegates treat enslaved people as full persons for representation purposes, but at the same time deny their humanity by treating them as property? Well, ultimately, Roger Sherman of Connecticut secured support for the 3/5 clause, which counted enslaved people as 3/5 of a person for congressional representation. That was a formula that had come from a tax law from the 1770s. And then there was the fugitive slave clause. There was little debate at the convention over the clause's language, but it granted Southern slaveholders the power to go to northern states to retrieve enslaved people who had escaped from enslavement. So we've reviewed the three major compromises at the convention about slavery, the banning of the international slave trade, the 3/5 clause, and the fugitive slave clause. So in the end, even the delegates who refused explicitly to recognize the right to property in men were open to protecting the existing property rights of slaveholders and were willing to compromise with Southern slaveholders in order to form the new Union. But the ultimate status of slavery, whether to permit it or to abolish it, was left to Congress and the states. While many in the founding generation predicted that slavery would eventually die out, advances in technology, like the invention of the cotton gin by Eli Whitney, made slavery more profitable and ensured its survival. There was a debate after the convention about whether the Constitution affirmatively protected the rights of the enslavers, as people like John Calhoun argued, or whether it left it up to Congress and the states to determine the future of slavery, as Lincoln argued. And in many ways, these debates culminated in the infamous Dred Scott decision at the Supreme Court, and eventually in the Civil War itself. Let's review the Dred Scott decision, which came down in 1857. Dred and Harriet Scott were enslaved people bought by an enslaver into an area where slavery was banned, and then returned to an area where slavery was permitted. And the Scotts sued for their freedom. They argued that their time on free soil made them free. It took 11 years for the lawsuit to get to the Supreme Court, and we often focus on Dred Scott's part of the story, but let's take a moment to recognize the important role played by Harriet Scott. She was an enslaved mother. She had two young girls. She didn't want them to live their lives as enslaved people, so she pushed to bring the case to court. And the Supreme Court eventually rejected the Scott's family claims, and they did much more than that. Chief Justice Roger Brooks Taney's infamous opinion for the Supreme Court also struck down the Missouri Compromise and essentially said that Congress had no power to ban slavery, even if it wanted to. And Taney based that decision on a false historical claim that at the time of the founding, African Americans were not citizens. Based on this reading of constitutional history, Taney concluded African Americans couldn't be citizens and that they had no rights that the white man was bound to respect. So the Scots couldn't get into court to sue for their freedom because you had to be a citizen to get into federal court. That was a bad enough ruling, but the decision went even further. The court went out of its way to declare the Missouri Compromise unconstitutional, attacking Congress's power to ban slavery in the territories, which was the core of the Republican Party's constitutional and political platform. Essentially, Taney was writing John C. Calhoun's radically contested vision of a pro-slavery constitution into the supreme law of the land. But Taney's arguments didn't go unanswered. He faced a pair of powerful dissenting opinions, one by Justice Benjamin Curtis and the other by Justice John McLean. Justice Curtis's dissent used history to show that at the time of the founding, 5 out of the 13 states did in fact allow for African Americans to vote and consider them citizens. So Curtis said, as a matter of original understanding, Justice Taney was simply wrong. And then at the same time, Justice McLean attacked the court for reaching out to curb the national government's power to ban slavery in the territories. In response to the Dred Scott decision, Justice Curtis resigned from the Supreme Court in protest, and leading Republicans, including Abraham Lincoln, during the Lincoln-Douglas debates, vigorously criticized the Dred Scott decision, and Lincoln said he would have to apply the decision to the facts of the case, as he was required to do, but refused to recognize it as valid law in other cases. In 1860, Lincoln was elected president and became the nation's first anti-slavery president. This led to a wave of secession by enslaving states in the South, and then, as Lincoln said so memorably, the war came. The war began as a battle to preserve the Union, but as it progressed, President Lincoln recast the war's meaning as a battle to end slavery. And he was pushed in that direction by African American refugees, abolitionists, and voices in Congress. The most famous example of this shift is Lincoln's Emancipation Proclamation. Drawing on his war powers as president, Lincoln issued the proclamation on January 1st, 1863. Lincoln was a great lawyer as well as a great emancipator, and he relied on his war powers, but he thought his war powers only empowered him to free enslaved people held within the Confederacy or within territories under military control. This was a great advance for emancipation. It was unthinkable before the Civil War, but at the same time, it didn't free all enslaved people. It didn't affect enslaved people held in the border states, which remained loyal to Lincoln and the Union, like Maryland, Delaware, Kentucky, and Missouri. Over time, thousands of African Americans signed up for the Union Army and laid claim to the promises of equal citizenship. And African Americans in convention, before, during, and after the Civil War, demanded their rights, petitioned Congress for equal rights, the same way Prince Hall did, including rights of free speech, religious freedom, and the right to keep and bear arms, and for the right to vote. And after the bloodiest war in American history, 23,000 dead or wounded at Antietam, President Lincoln and the Union prevailed. And after the Civil War, the Constitution was finally transformed in its text forever. And the Reconstruction Amendments, ratified after the Civil War, the 13th, 14th, and 15th Amendments, inscribed the promise of the Declaration into the Constitution. The 13th Amendment, ratified in 1865, abolished slavery. The 14th Amendment, ratified in 1868, wrote the Declaration's promise of freedom and equality into the Constitution. It combined 4 big ideas. First, birthright citizenship. The first sentence of the 14th Amendment overturns the Dred Scott decisions and holds that African Americans do have rights that white people are bound to respect, that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Dred Scott is hereby overturned. Second, equality. The original Constitution is silent on the issue of equality. Now the Declaration's promise that all men and women are created equal is written into the Constitution. And indeed, women's suffrage advocates at Seneca Falls invoke the promise of the Declaration in their Declaration of Sentiments to insist that the promise of the Declaration and the 14th Amendment apply to men as well as women. And third, freedom. The original Bill of Rights was limited to abuses by the national government. Now the Constitution protects those from abuse in the United States by the states and applies the key rights of the Bill of Rights, like free speech and religious liberty, to the states and holds that the states as well as Congress can't infringe them. And fourth, national power over civil rights. Congress is given the power to enforce the protections of the 14th Amendment and expands Congress's ability to protect freedom and equality. And finally, our third amendment is the 15th Amendment, which was ratified in 1870, which promised to end racial discrimination in voting. So we've seen how the promise of the Declaration of Independence, that all men are created equal, was thwarted in the original Constitution, resurrected by Lincoln and Frederick Douglass, inscribed in the post-Civil War amendments to the Constitution, thwarted again after Reconstruction, and resurrected again by Dr. King on the Washington Mall, and In the I Have a Dream speech, Dr. King said, "When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This note was a promise that all men would be guaranteed the inalienable rights of life, liberty, and the pursuit of happiness."